And we're rolling. Hello, good evening, and welcome to another edition of Car Brief, a web channel dedicated to bringing to you all the interesting case law out there that is relative to automotive related law and various facts that involve lemon law and racing and so on and so forth. Just have a brief story to tell you with regards to this outfit I'm wearing right now, black shirt and a rather orange looking tie. I was admonished by the judge today while I was in court. He told me never to wear this tie again in his courtroom because I looked like the Undertaker for Halloween. And at first I thought he was serious, and I kind of covered up the tie with the rest of my suit coat. But he said he was just kidding. But in retrospect, I question whether he was kidding or not, because why would he have even mentioned it? So I don't believe I'll have an opportunity to wear this outfit because the next court date's beyond Halloween, and we are approaching Halloween. So I thought it appropriate to wear this sort of get-up. And maybe I shouldn't have in retrospect, because I did trigger the judge to indicate that he didn't want me to wear this tie. And I certainly won't make that mistake again next time I'm in front of him. Tonight we're going to talk about a case that involves street racing and speeds in excess of 100 miles an hour, 40 miles over the posted speed limit. This is a case of People versus Lewis. It's an appellate court case out of the First District of Illinois. It was decided October 29th of 2014. Still good law as far as I can tell, and let's get into it here. This case involves a bench trial where the defendant, Mr. Lewis, was found guilty of speeding 40 miles per hour or more than excess of the speed limit, street racing, improper lane usage, and failure to signal, and he was sentenced to concurrent terms of 12 months, conditional discharge as to all the convictions, as well as assessed $660 in fines. Well, obviously, Mr. Lewis wasn't satisfied with this result, which caused this appeal. Now, let's look at the facts here. At trial, the Illinois State Trooper Aaron French testified that approximately 1:10 a.m. on November 20th of 2011, he was on patrol while in uniform and driving an unmarked car. He was traveling northbound in the middle lane of 3 lanes of traffic on I-94 just south of 158th Street when 2 vehicles went past on either side of him at a high rate of speed. One of the cars was a black Mercedes and the other one was a green BMW. So these are high-end German cars. You kind of can figure that these guys were testing their limits on the highway. And they certainly didn't know that Officer French was in the area. Otherwise, they probably would have slowed down considerably. In any event, Trooper French attempted to catch up to the vehicles and in the process accelerated to over 120 miles per hour. He continued to drive at that speed for a little over a mile from 159th Street to just below 147th Street, but both vehicles were still pulling away. So they were probably going really, really fast. If he was doing 120 and they're still pulling away, you can reasonably infer that they were going well beyond the posted 55-mile-an-hour speed limit. During that time, both the drivers swerved around other cars 4 or 5 times. They failed to use their turn signals and kept about the same pace as each other. Trooper French was able to catch up to the vehicles when they were exiting at 147th Street, and when the vehicles were stopped at a stoplight, Trooper French activated his emergency lights and used his public announcement speaker to instruct the drivers to pull into the White Castle parking lot at the 147th Street exit area. The driver of the Mercedes, who Trooper French identified in court as defendant, followed his instructions and pulled into the parking spot. The other driver, however, went through the parking lot and exited back onto the roadway, so the BMW got away. That was a penalty that the driver of the Mercedes paid. He actually stopped and obeyed the officer. The other one got away. So Trooper French further testified that he then approached the defendant and asked him why he was driving so fast. The defendant responded that he had seen the green BMW go past him, and he was just trying to keep up the speed with him. Trooper French issued citations to the defendant for street racing and for speeding 100 miles per hour in a 55-mile-per-hour zone. He was probably going faster than that, given what French had testified to. So French wrote the ticket for 100 because he figured he had no speed on him besides for them pulling away from him, and he was doing 120 miles per hour, so he figured at some point in time they had to be doing 100 miles an hour. So in other words, the trooper here was estimating the speed. He didn't get an accurate read from a radar detector. He just eyeballed it. He just visualized it and made an estimate. Well, that created an open avenue of cross-examination by the defendant's attorney, and on cross-examination, Trooper French testified that at the time of the incident, the traffic was moderate and that both vehicles passed him at approximately the same time on either side of him, traveling parallel to each other. After the vehicles passed him, they remained neck and neck. Although he had a radar unit in his vehicle, he was not able to use it to determine the defendant's rate of speed because in order to do so, he would have had to have been going slower than the other vehicles. On redirect examination, Trooper French testified that he has been a trooper for 3 years and has done traffic patrol on every workday. He has driven a car at 100 miles per hour before and is familiar with how objects look when they pass by traveling at 100 miles per hour. So that's how he was rehabilitated by the prosecution when they did their redirect examination, to show that he was credible to be able to testify to the estimated speed based on what he saw visually. Well, the defendant testified that he was on his way to work at the time of the incident. Well, I wonder if he was an ambulance driver. And he was not following anyone at the time. Although he admitted that he had been speeding, he denied that he had been traveling at 100 miles per hour and estimated that he had been traveling at between 75 and 80 miles per hour. The court found the defendant guilty of speeding 40 miles per hour or more in excess of the speed limit, street racing, improper lane usage, and failure to signal. In doing so, the court stated that Trooper French's testimony that he had approached a speed of 120 miles per hour, but the distance between his vehicle and the two vehicles he was pursuing continued to increase, showed that those two vehicles were traveling faster than the trooper's vehicle. The court subsequently sentenced the defendant to a term of 12 months conditional discharge, as mentioned before, as to each conviction, and assessed $660 in fines. On appeal from the judgment, the defendant does not contest that he was speeding on the night of the incident, but argues that the evidence was insufficient to show he was speeding 40 miles per hour or more in excess of the speed limit. So he's going to try to challenge the speeding charge, or the conviction actually, and the street racing charge. The court goes on to note that the standard of review when it's in the appellate courts is that the sufficiency of the evidence is whether, after viewing in the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. So they're giving the prosecution the benefit of the doubt because the prosecution's not the moving party, so to speak. The prosecution's not the appellant. They are basically defending an appeal, and you're going to look at it in a light most favorable to the non-moving party, as it is in civil actions. So the court goes on and they state that it has been held that an officer's estimate of speed at which defendant was traveling is sufficient to sustain a conviction for speeding. And that's based on another case, People versus Hampton, which is an older Illinois case, goes back to 1981. So there again, you can see how stare decisis operates in the law, where courts look to decisions made in prior cases to give them guidance as to how they're going to decide this case. Basically, stare decisis is Latin for let the decision stand, and they're going to use what's called precedent to follow older court rulings or court rulings that are nearly concurrent with what they're deciding. That shapes the body of case law and gives us guidance as lawyers and judges to determine how a particular case is going to be decided before you. Well, the court goes on to note that the Trooper French further testified that he began to pursue the defendant, and although his speedometer reflected that he was traveling at approximately 120 miles per hour for a little over a mile, defendant's vehicle was still pulling away from him. Trooper French thus estimated the defendant's speed at this time reached at least 100 miles per hour. So there they go, once again viewing the evidence in the light most favorable to the prosecution. Another case cited, Siganuza Brito, we find that it was sufficient to show the defendant's speed at the time of the incident was 100 miles per hour. So the defendant's kind of going down in flames with their argument that they weren't speeding at 100 miles an hour because the trooper was able to estimate given a visual. So the speed of 40 miles per hour or more in excess of the speed limit was found guilty beyond a reasonable doubt. So the court's not going to overturn it based on that argument. Now, getting on to the street racing aspect of the case, the defendant challenged the sufficiency of the evidence sustained on his conviction for street racing. In so arguing, he correctly points out, according to the court, that there was no indication of which subsection of the Illinois Vehicle Code he allegedly violated, given that no subsection was listed in the citation he was issued, and no mention of a particular subsection was made at trial. So the prosecution kind of messed it up there, and so did the officer by not citing a specific section of the code as to the street racing. However, the appellate court's going to say, and they do say, we may affirm the trial court's judgment on any basis supported by the record. And they go through the street racing code, and they go through the various sections of the code, and they go on to state that the defendant maintains Trooper French provided no testimony regarding any actions that would constitute street racing pursuant to any of the enumerated subsections. The Court of Appeals disagreed. The court noted that Trooper French testified he was traveling in the middle lane of 3 lanes of traffic when defendant's car and the green BMW passed on either side of him at a high rate of speed, and that the cars were neck and neck. And we find that the evidence presented was sufficient to show beyond a reasonable doubt that the defendant was using his vehicle in an attempt to outgain or outdistance the green BMW, and was thus proven guilty of street racing pursuant to subsection C3 of the code. I just wonder if this BMW and Mercedes knew each other, or if this was some sort of a duel that just kind of formed just underground, unexpected. You see somebody race past you, and then you basically want to catch up to them to see what they've got or what they can do. Who knows? They might have known each other. They may not have. We'll never know. It's not revealed here in the record, but it makes me wonder sometimes the backstory of this. Well, the court goes on to note the defendant's next argument of that his conviction for speeding and street racing violate the one act, one crime doctrine. In Illinois, we have a one act, one crime doctrine. Under that rule, a defendant may be convicted of only one crime resulting from a single act. And accordingly, where 2 convictions arise from the same physical act, sentence should be imposed on the more serious offense, and the less serious offense should be vacated. So here the defendant maintains, and the state concedes, that his convictions for speeding and street racing violate the one act, one crime doctrine because they were based on the same physical act. So now we have the prosecution on appeal agreeing that the one act, one act, one crime doctrine applies to this case. Now it becomes an issue of which one is going to get dismissed. Is it going to be the street racing, or is it going to be the 40 miles over the limit? Well, the court goes on to note that the question of those 2 convictions is the less serious offense. In making this determination, a court should compare the relative punishments for each offense, and if the punishments are identical, a court should consider which offense has the most culpable mental state. Well, that's maybe a bit tricky here. The street racing probably has a more culpable mental state because you're going to engage, you're going to put some thought into it before you actually engage. Whereas speeding, as it was held in other cases in the past, could be inadvertent. You may be just keeping pace with surrounding traffic, which is also speeding, and it's not a conscious thing. So the mens rea, or the guilty mind, is more associated with street racing. That's ultimately what the court held. The state asserts that remand is not necessary because it's the right to elect which conviction should be retained, and in this case it elects the street racing conviction. We note that unlike a conviction for speeding 40 miles per hour or more in excess of the speed limit, a street racing conviction is subject to a minimum fine of $250, and here's the kicker, mandatory revocation of the defendant's driver's license. What do you think they went with? They went with street racing as the conviction, and they accepted the state's election and directed the offense of speeding 40 miles per hour or more in excess of the speed limit be vacated. So the defendant in this case, he suffered a revocation of his driver's license. And in Illinois, it's not like a suspension which ends on its own terms or its own time period. A revocation means you actually have to make an affirmative application with the Secretary of State to get your license back. So it's a much more serious fine. That's what they went with. And the takeaway from this is you just got to be alert out there, and it could, just because it's 1 o'clock in the morning doesn't mean there isn't some officer patrolling somewhere along the interstate like a great white shark that you don't see that fin until it's too late. So the takeaway is be on your guard and drive safely. And that's all I have for now, and I look forward to downloading another video for you. I believe my download times or dates will now be Tuesdays and Saturdays, so 2 a week. If I can manage 3 a week, I'm going to do it Tuesdays, Thursdays, and Saturdays, but this last week's been a bit of a bear for me, and I just didn't have the opportunity last night. So I will sign off. It's Friday night, October 18th, 2019. I look forward to download another. And if you like, please hit the like button, subscribe, and hit the bell. Take care and happy boating.